A district court in Surat today convicted and sentenced Congress leader and Wayanad MP Rahul Gandhi to 2 years in jail in a criminal defamation case over his Modi surname remarks in 2019. He has been convicted under IPC sections 499 and 500. According to the Representation of the People Act, Section 8 on disqualification on imprisonment, a lawmaker will be disqualified if convicted and sentenced to imprisonment for 2 years or more for the period of imprisonment and another 6 years after the imprisonment. Though pronouncing the conviction verdict, the sentence of 2 years has been suspended for 30 days and the court has granted a bail to allow him file an appeal with the appellate court. Will Rahul Gandhi face disqualification? Let's get into the legalities involved. Uncertainty looms large whether Rahul Gandhi would face disqualification and Election Commission would announce a bypoll in Wayanad, or the MP gets one chance to continue being the people's representative. If the appellate court doesn't stay the conviction, then he will be subject to disqualification under the Representation of the People Act 1951. The law says that once there is an order of conviction with a sentence of 2 years or more, she or he stands automatically disqualified from the day of conviction unless and until in an appeal that conviction is stayed. Section 8.1 and 8.2 of the Representation of the People Act deals with specific offences like terrorism offences and offences under Prevention of Corruption Act. Section 8.3 of the RPA says that any person who has been convicted of an offence and sentenced to an imprisonment for not less than 2 years shall be disqualified from the date of conviction. And Section 8.4 says that any disqualification under these criteria shall not come into force until 3 months have elapsed from the date of conviction. However, this was set aside by the Supreme Court in 2013 as ultra-vires, citing that it is beyond the scope or in excess of legal power or authority. Now, does Rahul Gandhi stand any chance to remain in parliament in or contest polls if the verdict is not overturned or stayed? Two things can happen. Either Gandhi will succeed in overturning the verdict or he'll fail. Speaking exclusively to OdishaTV.in, advocate of the Supreme Court of India Vivek Raja said, if Rahul Gandhi succeeds in his appeal, the disqualification will be automatically vacated. Even if he gets a stay of the conviction while the appeal is being decided by the appellate court, he will not be disqualified. However, if the appeal court does not grant an interim stay of the conviction and finally upholds the conviction already pronounced by the trial court, he will stand disqualified from the date of conviction, which means disqualification shall continue for a further period of 6 years from his release. However, the trial court verdict will be vacated if the appellate court overturns the order. The barrister further clarified that in any appeal, when an appellate court overturns the verdict of the trial court, automatically the trial court judgment goes away and it merges with the appeal court verdict, and subsequently the appeal court verdict will then be the final decision. This also means that the initial conviction won't hold ground anymore, but for that, Rahul Gandhi will have to succeed in his appeal. But if he doesn't manage to get a stay on the conviction, he will eventually be disqualified from participating in parliamentary proceedings and neither can he contest the polls. Even before the Election Commission comes into the picture, he will stand automatically disqualified under the provisions of the Representation of the People Act. Here, it is pertinent to highlight one such previous incident wherein former MLA of the Samajwadi Party Azam Khan was immediately disqualified from Uttar Pradesh Assembly after a trial court sentenced him to 2 years imprisonment in a criminal case. So all eyes will now be on the decision of the appellate court. Stay tuned for more updates. Subscribe to our channel OTV News English.